Imagine being forced to confess to a crime you never committed. Imagine enduring physical and psychological pain until you sign a statement under duress. To many people, this may sound like a scene in a movie, but to many Nigerians, this is the painful reality they live in. One such case involved a 16-year-old boy from Delta State who spent a decade on death row before evidence emerged that exposed the truth behind his ordeal. Similar allegations have surfaced in other parts of the country, including Kano State, where some individuals have claimed to suffer abuse while in custody. Every year, on the 26th of June, the international community marked the International Day in support of victims of torture, a day dedicated to raising awareness about hardship of victims of torture and promoting the protection of fundamental human rights. Torture is the deliberate infliction of severe physical and mental pain on a person, typically to punish, intimidate, or extract information from them. Today, we ask the difficult question, but necessary question. What happened behind those walls of detention facilities? How are allegations of torture investigated? And who is held accountable when the right of a citizen is being violated?
Gaskiya dai na haɗu da cin zarafin da ban taɓa fuskanta ba a rayuwata.
On 3rd August, I was out with a friend and my sales boy, a businessman, when the police stopped us. At some point, I lost consciousness. By the time we got to the police headquarters, they treated us as though we were criminals or terrorists. They beat us badly. I cried until I had no strength left to cry. They knocked our heads against the wall and stamped on us. They beat us. At no point did anyone tell us what offense we had actually committed.
Kuka sai da ni na kuka.
To, ni dai babu abin da na yi, saboda ranar gaskiya na fito ne zan tafi gurin aiki na.
I had simply come out to head to my workplace, stopping briefly to eat at Kopar Gadang Kaya. While I was standing there, someone grabbed me by the chest and threw me into a vehicle. Inside, I saw Nigerian flags. I was taken to Gwali, where they questioned me why I had come out, what I did for work, and whose flags those were. I told them the flags were not mine. I had only seen them inside the vehicle, but they insisted we were trying to rent the current government's region. The holding facilities was unclear and smelled strongly of urine. We all felt suffocated. I felt disappointed and sad. I had never been to police station before. I was asked questions I had no answers to, and I didn't even understand. Even now, the memory still saddens me whenever it comes to mind, but I hold on to it as a test from God, and I believe I will come through it.
Hudocin da mu ma ba mu so aka ce za a yi mana hotuna.
My name is CSP Abdullahi Haruna Kiyawa, the Police Public Relations Officer of Kano State Police Command. The ACGL in Kano State provide details of what the security officials or police officers need to do whenever a suspect is arrested. Even at the point of arrest, you have to introduce yourself for police as a police officer, then the reason for either the invitation or the arrest. If a suspect is in our custody, he has his own rights. Firstly, we need to obtain their statements in front of their lawyers or relatives. In situation where we don't have their lawyers or relatives, we get lawyers from Ministry of Justice that they used to assist while obtaining statement of the suspects, and we treat them with dignity and respect. Police officers always received various training in terms of all aspects of policing, administration, operations, and of course, including investigations. We have it here, and I will take you around so that you will witness and see where we used to keep our suspects. There are provisions and conditions for keeping suspects, and whatever we do, we are always accountable, because where we keep them used to be very neat. We keep them very warm. Where they need medical support, we link them up. And whenever they wanted to see their lawyers, it's very often. And even provision of keeping this suspect is stipulated by law. The window is 24 hours, highest 48 hours. We now proceed to the court. We are using digital equipments, forensic examinations, forensic investigations, and we have our various units, the cybercrime, the modern units that investigate all these digital aspects of investigation. Anti-Torture Act of 2017 is very clear. It's not permitted. The Constitution of the Federal Republic is also very clear about anything that has to do with torture. When you go through the Anti-Torture Act very well, you know that torture is prohibited in Nigerian law currently. So just like every other individual, there are some rights when he is in a custody. He has right to contact his lawyer. He has a right to be given medical attention when needed. He has right to only say whatever he wants to say without duress. These all are right of suspects in our custody.
My name is Usman Umar Fari. I'm the current chairman or outgoing chairman of the Nigerian Bar Association Kano branch. It has now been defined by an act made by the National Assembly in the year 2017. The act is called Anti-Torture Act 2017. It has broadly defined torture and what torture means. So any person looking for the definition of torture, it is very comprehensive. He can go and look section 2 of that particular act where the torture was broadly defined. Where torture still exists. Despite the promulgation of the Anti-Torture Act 2017, the provision of that particular act are not being observed by the relevant government officials. For instance, in that particular law, there is a provision that a unit must be inaugurated in each of the government's law enforcement agencies, saddled with the responsibility of enforcing or complying with the provision of the Anti-Torture Act. So, like other law enforcement agencies, even some of the courts are not even aware of this particular law. It is like something new to them. But in that particular law, any confession extracted out of torture cannot be admitted in evidence in any court. It's part of the provision of the Anti-Torture Act 2017. So, but not solely on torture, because normally torture is conducted in course of investigating a matter by the law enforcement agencies. So in course of that, they can commit a torture. So I have prosecuted many cases in which some aspect or element of torture were part of the issues that we raise in the cases, of course. The torture, well, I can say one may say it has reduced, but in some aspect it has not reduced. What they should do, they should file a case, they should see a lawyer to file a case of fundamental human rights, because right to be free from torture, degrading and inhuman treatment is part of the provision of the Constitution under Chapter 4. And where a person, one of his fundamental rights enshrined in the Chapter 4 is infringed or is likely to infringe, he can approach either the Federal High Court or State High Court for redress. And apart from that, he can lodge a complaint with the National Human Rights Commission for the purpose of the torture and seek redress. The only issue is that if he file a case in a court, now because of some of the decisions of the courts, they are saying that you can only get a monetary compensation if only your right to liberty is infringed or right to immovable property is infringed. If those decisions are followed by the courts, so it means that he will not be compensated.
Torture leaves scars that are far beyond visibility, manifesting trauma, fear, physical pain, and memories that are difficult to forget. Under the international human rights law and the Nigerian law, torture is prohibited at all circumstances. That is why this day remains significant. It serves as a reminder of the need for accountability, justice, and protection of human dignity. It also gives a voice to those who continue to seek recognition, reform, and redress.